And welcome back, and thank you for staying with us. We'll continue with our conversation very shortly on the electoral law amendments, and if only you could hear us off the air. We'll come to it shortly with my guests, but first we want to give you a quick update of what's happening at the law courts and take you to Machakos now, where our correspondent Enoch Mutua is standing by. You will, of course, remember that IEBC was compelled by the court in the case in which Governor Mutua is facing Wavinya to surrender poll materials in that particular case where the former Kathiani legislator is seeking the nullification of Governor Mutua's election. So Enoch joins us now on phone this morning with more information. Enoch, what can you tell us? What are we expecting to hear from the courts this morning?
This morning we are in Machakos Law Court where Wavinya, former Kathiani MP and former candidate for the governor's seat, has petitioned IEBC on the election results that were announced on August 8th, where Governor Mutua led with 249,954, with Wavinya garnering 209,233, where she alleges that according to the results, there were so many irregularities, and that's why she has come to court. And the court sat on September 24th and ordered IEBC to bring all the election materials to the court today on 4th October so that they can check the materials and scrutinize them before the court. According to Wavinya, the counting and some of the materials were not in order in the August 8th election. And according to the IEBC lawyer, Kimani Muoro, who earlier on told the court that what they can provide to the court was only the SD cards, because the King's kit that were used for the August 8th election are being formatted for the preparation of the presidential repeat election slated for 26 October. And he later on accepted after the court pushed them on and said that today they'll provide the materials plus the copies of 37As so that the court can scrutinize and check whether what Wavinya is saying is true. Among the lawyers that are representing Governor Mutua are 15 lawyers led by Kioko Kilukumi, Mohamed Nyaoga, BM Mungata, Wilfred Nyamu, among others. Wavinya on her side is being represented by 15 lawyers, where the team is led by Orengo and Martin Gitonga, who among them have not arrived in court yet, but the case has started, and the judge sitting for the case is Justice Agri Muchelule, and the case has just kicked off around 5 minutes ago.
All right, Enoch, just before I let you go, if you could clarify to us what you may know about the form the scrutiny will take. Are you saying that we can expect the court this morning to have those ballot boxes opened and a recount done, or what form do you understand scrutiny will take today?
As I told you earlier on, what the court asked was the election materials, and as the court was starting, I've not seen any ballot boxes, but maybe they've been kept somewhere in the court premises. But I can confirm that the IEBC returning officer in charge of Machakos County, Madam Joyce Wamalo, is in court, so maybe she'll clarify where the ballot boxes are and the election materials, maybe through our lawyers. So we are yet to know, but that was what the court had asked when it sat on September 24th here in Machakos.
Okay, and thank you for that. And so we'll be, of course, watching the Machakos Law Courts for you this morning to find out what form scrutiny would take in this particular case. Enoch Mutua is speaking to us. He's our correspondent. All right, let's take you now back to County Hall and listen a little bit to more of the public and private institutions making their submissions before the Joint Select Committee of Parliament into these proposed electoral amendments.
That we needed to expand this provision by including not just the returning officers, because in the entire electoral system you have got so many people who are all responsible for the electoral process, and each one of them has a role to ensure that the election is properly done and credible. And therefore our proposal is that this offense should be expanded to include commissioners and any other officers with responsibility in the electoral process, because when you give exemption and only target returning officers, then you leave quite other critical players with opportunity not to do things the right way. And the matter of on the matter of media, permitting media to announce elections once they are announced by the constituency returning officers. Media are members of the business community, and after consultation we do agree that media should not be restricted from announcing the results once they are declared, so that the members of the public can be fully informed about the outcome from the various stations. Chairman, that gives the overall areas that we looked, that we have proposed we would like to improve on these electoral laws. I would like to give an opportunity to Caro to add or improve one or two other areas, and then we shall complete our submission.
Proceed.
Chairman, there are two areas we looked at that we felt that though the Act hadn't looked into amending, the area of technology, and we know it was a big issue that came up in the last Supreme Court ruling, and it is an issue that, and because we've talked about technology being part of the election, and one of the areas that we looked at that could, as new proposals, one is the definitions. We know the cybercrime bill is still in Parliament, and we felt that though that may take a long process, there are areas that it touches on the electoral law because of the technology used. And so we picked two areas that we felt would improve these amendments, and one is on the definitions. And we talked about the definition of computer systems adopted is the same as proposed, should be the same as proposed in the Computer and Cybercrimes Bill 2017, which is extensive and anticipates all forms of technology. So if you could adapt that, and reference to a computer system encompasses all forms of technology and provides for dynamism in the ICT sector. The existing definition of an integrated electronic system leaves out a key component that the system should be computer-based. So we need to look at pick those that are in the cybercrime bill and add them into the amendments here. The second one that that we picked up in the technology area is on the subject to the section that there is established an integrated electronic system that enables biometric voter registration, electronic voter identification, and electronic transmission of results. This we feel strongly that this is to streamline section 44.1 on the amendments affected in section 2, changing the definition of an integrated electronic electoral system and including the definition of computer system. That if you put that together with what is in the cybercrime bill, it will answer a part of that. This is also to clean up the section to avoid repetition, as the aspects of the systems are captured in the definitions clause. So if you bring that back to where the definition clause is, it will remove the issue, so that if there is issues of hacking, there's a law again that talks about that, so that we don't have that vacuum where people could talk about hacking, but you couldn't use a law. There was no law to say this is the law we're going to use to take you to court or anything else. So we felt that bring that in, even as the cybercrime bill continues to go through process, but pick those areas that affect the electoral management and bring them into the electoral law. So those are some of the areas that we picked, and again, as we said, our submission was very restricted to areas we felt we could add improvement, but areas of also support. So we do support a lot of the amendments done, but what we have looked through is how do we improve those, and also looking at long term. So our basis of submitting today is looking at the long term use of the law. Thank you very much.
Thank you, Kariuki and your team. We want to appreciate your presentation. we will definitely take into account, especially those other proposed amendment areas that you feel we need to consider to strengthen these amendments. We want to appreciate. We know that you represent, 500,000 membership, and I think it's a huge population. We want to request that you give us your written memoranda so that we apply, and as we do our final report. Thank you very much, and we appreciate your contributions. Members, do you have anything to... just a moment. I'm trying to be a bit fast. Honorable Kiruyot, and then Kiambu.
Thank you, Chair. Thank you, Kepsa, for that presentation. I just have I'd wish to get your comment. There's been a general discussion that as politicians, unfortunately it's not by design, we've unnecessarily dragged the country into a very long political season that has hurt the people that you represent so much. I thought it would just be good to hear your comments on the same. How bad is it, and are there any specific laws that you wish to propose either now or in the future that will stop the same from happening? Thank you.
You don't need to. Let us first of all get comments from members, then you can respond to all of them. Shamala, Honorable.
Thank you, Lee, Wairimu, and Carol, for your presentation. It's most appreciated.
All right, and so we've been hearing from KEPSA through its leadership giving their responses to the committee, pretty much saying that they support the amendments but would want them augmented. Joining my panel this morning is Joseph Simeha. I got it right, didn't I? Thank you. He's a political analyst. And thank you for coming on board alongside the rest of my panel that stays this morning. Joseph, let's just begin with your preamble, your thoughts on these amendments, the timing, and the process that is underway right now at County Hall.
My position is that any amendments on the law governing elections, amendments of the law or even creation of new law, is a continuous process for Parliament anyhow. But for the law governing elections at this moment, when we are in the middle of an election, it just stinks of mischief. It's just not the right thing to do. Even however well intended it may be, by the way, it's impossible for other parties who are involved in this election not to read mischief. So the best thing would be let's try our very best that in whatever we do, we avoid anything that may raise suspicion and make our competitors ascribe mischief to what we are doing. If we think it's extremely important that it happens and it's in the interest of the nation, then the approach has to be bipartisanship. Then the approach has to be a negotiated approach, just like the laws we have currently for elections, which came into operation barely 6 months or thereabout to the last eight elections. It was a bipartisan process so as to build confidence and trust, not just in the process of making the law, but also in the output, in the product of that process. So just now, unfortunately, you can't help but read mischief in it, and especially with specific, even when you look at very specific provisions that are being proposed. Some provisions, for example, qualifications of a chairman and so on, at any other time, one wouldn't question it. In my personal opinion, from my experience, you do not necessarily have to be a lawyer to be a chairman of the Electoral Commission. I mean, Electoral Commission has the legal department, has lawyers and whatnot. You do not. It's more about managing electoral processes. So that can pass. It sounds like a very reasonable and good proposal. But there are other proposals that sound very mischievous, because when you look at, for example, two of the provisions of the Constitution on functions of the responsibilities, rather, of the chairman, not any other person on that commission can undertake those responsibilities, and that is pronouncing the results of a presidential election, therefore acting as a national returning officer, and also handing over the certificate to the incumbent president and the Chief Justice. It could not be anybody else other than the chairman, which is expressly provided for in the Constitution.
So when Jubilee say that particular provision is about good governance, continuity?
We can bring it at any other time. What is the urgency? Do we have some information that Chebukati is about to fall sick or dead or something? We can bring it any other time, in all honesty. We do need to keep improving our institutions, our processes, our policies in this country, no doubt about that. But the timing is just not right when we are in this middle of a presidential election. It's basically what people are saying, changing the rules when the game is on. It's just not right.
Let me pick up from the environment and the timing. And earlier, Dr. Kamau had talked about the fact that we're working in a polluted environment, and as a result, you can expect that our objectivity is clouded. Everybody's seeing this from their own sides. What do you think about the political environment that may prejudice, if you were to give them the benefit of the doubt, otherwise good and progressive legislation?
Absolutely. I mean, even if you were to put aside the fact that we're going to have a presidential election, we're not in the middle of an electoral process, just the political environment, the current political environment, which is inevitable, by the way, when you are having a highly contested presidential race. It's inevitable that you get this kind of hardened positions and so on, and especially given the manner in which the results of the previous election were announced, 8 elections, that it was established by the process of the court, that there are certain illegalities committed by the IEBC. It makes those who feel that they lost unfairly very jittery, extremely jittery, that they want to put IEBC under, and rightly so in my opinion, fairly so, under the spotlight. And we all should as Kenyans actually, because it's unfortunate when we imagine that the people who are disadvantaged are just Raila Odinga and his team. Actually, all of us were disadvantaged by the messing up of, even I use that word, of elections by IEBC. It costs all of us Kenyans. So the environment is inevitable, given the type of election we are having, and it does completely make it difficult for people to trust each other. It is really the wrong time to bring up a law. And I'm telling you, they could bring up some law on agriculture or something, and it could probably still be just as bad. That you don't trust these people, they must be up to something. We cannot trust them until after this, unless there's some kind of emergency. If it's a law about some emergency or a process that is extremely urgent, yes. But anything else, I think they best hold it until after we are done with these elections, and then we can come together as Kenyans and say, how do we improve our electoral policy processes and procedures?
Irungu, do you see that? Do you see the working in a polluted environment being critical in the process of passing legislation?
No, if at all what we are trying to pass is something that is hidden, something that we are going to unveil at the maybe yes, maybe his arguments would hold. But here we are talking of proposals which everyone can see, which everyone can interrogate. And I want to reiterate, any proposal, whether it comes from Jubilee, whether from NASA, is always good proposal so long as it's cogent. So I think what they should, my friend should be telling us what is wrong with these proposals, because we need to ensure we do not have a situation where we are back to the Supreme Court. The victory, whoever it is by NASA or even by Jubilee, is nullified, and therefore the proposals are aimed at ensuring we have a free and fair election. A good example is the one concerning punishing officials of IBC who fail to sign required documents, who fail to append the stamp, who use forms which do not have certain marks. What prejudice is NASA or even countries going to suffer when we enhance penalties for such officials? What prejudice? What prejudice is Raila going to suffer if those proposals become law? I thought Raila Odinga should be celebrating. We are doing that which he complained about. He went to the Supreme Court, cited those reasons. We are now entrenching his arguments into law. What prejudice? My friend has not given us a single point.
Let's allow him to respond to it. Before I open it up to
First of all, I should hope, if they are doing exactly what Irungu is saying, I should hope that they've talked to Raila Odinga and he's said, please go ahead and do this on my behalf, because that's what they purport to be doing. They are doing this on behalf of Raila Odinga and NASA that asked for this. But anyhow, let me go specific to what prejudice, what is the mischief that one sees in what Jubilee is doing. One, the Supreme Court not at any point did it ever indict the law. It did not talk about any weakness in the law. It indicted the system at IEBC, the institution at IEBC, the workings and management of IEBC.
No,
how IEBC...
Can I quickly...
let me finish, then you'll be given a chance. How IEBC handled the election is what was indicted. Secondly, whereas one at the face value, prima facie you can look at, for example, the one proposal that Mheshimiwa has given as an example, and say that yes, let us enhance penalties so that if any returning officer commits an illegality or even an irregularity, we punish them. At prima face value, it sounds quite okay. But hold on a minute until you check and find out that actually IEBC has remedies, has administrative remedies, and beyond that, it can take this person to court. They are actually remedies. So this reeks of what we've had in this country of, for example, there being a prescribed penalty of this amount of money or jail term, but yet it's never enforced. But again, look at that vis-a-vis, look at that proposing to punish arrows, which on face value is fine, for failing to sign, particularly to sign a form, but then saying what may be on that form, regardless in what form it comes, cannot invalidate an election. In other words, in simple words, I'm saying you are most concerned about signing a form by the returning officer, but you are not concerned about what goes onto that form, which is extremely important. In fact, it was the basis for nullification of that presidential election results. We must just as much be concerned if we don't want people to read mischief in this. Otherwise, you can make returning officers sign forms, and you fill onto them whatever you want, and you manually bring them to Nairobi, and you cite the law and say, well, the law says whatever is on the form cannot invalidate an election.
Okay, right. Dr. Kumar.
Well, I think there are a couple of issues again as we look at this whole debate. I had said earlier that a bipartisan approach would have been ideal, for the simple reason, if the parties could come together and agree as a result of the experience of 2017 August 8 elections and the Supreme Court judgment, there are certain issues that came up, and I think we all agree. For example, I know IEBC meant well when they put in place, that mechanism of how the results will be transmitted. And there was a lot of contention around that. The fact that, of course, there was the text-based sending of results, there was also the scanned form, and there was also now the manual form itself. But the question came up, and you saw that confusion even at the Supreme Court when people were asking, what is it that was displayed on the screen? Was it, the terms that were used were statistics, the other term was data, because we're afraid to use the term results. So there are certain confusions because of certain practices, and that is why I partly agree with what you're saying. There were issues within IEBC that it was not very clear, even from the law. We're trying to understand, so what is it that we are seeing, especially based on the minor case, what is it that we are seeing on the screen? And I think part of one of the provisions in these, is to try and cure that, so that when you create for the live streaming of results, to create some level of what you'd call accountability, but also make sure that the chairman, the final declaration, everything that he declares has been verified. It is actually backed by an existing form. So that is why I'm saying we need to look, what are some of the issues that this provision seeks to cure? But on the other hand is, what are the mischiefs or loopholes that we are opening up? But the question is, are there existing loopholes in the law? Because in a political game, people will always take advantage of that, that we are seeking to cure through these specific laws. And are we opening new loopholes? Now we try and balance that and see what is the greater risk, because there is actually an existing risk. For example, that issue of the chairman in terms of if anything was to happen to him, and it shows it's just an issue of risk trying to manage
if anything was to happen to him, or can we just be frank that Jubilee's suspicion is that somehow the chairman may not 100% be independent and was intending to resign? Irungu, is that it?
I think I would want to look at it.
It's a possibility. You never know. You never know, of course. But
this is what we hear whispered.
It is a possibility, but that's neither here nor there. The issue that we must address ourselves
is that what motivated that very particular?
No, it is for posterity of Kenya, and by the way also, and also a realization which was jolted after we noted one judge who failed to attend the Supreme Court case. So therefore we thought, oh, this can happen in this institution. It can as well happen here. But be that as it may, my colleague here has said that we have laws which can be used to punish what I can call bad officials of IBC. It's not true. You have to understand the nature of criminal law. In criminal law, you have to be very precise, unlike civil law, because you are talking about a person you are about to take to jail or fine or in prison. So therefore, in criminal law, you need to establish a clear offense and you establish a clear penalty. Presently, when you look at the Elections Act, we don't have a clear law punishing errant IBC officials. And essentially,
beyond IBC regulations, is what you're saying? Beyond the IBC's own regulations, you don't have it established in law?
Yes, we do not have. And if you are to try to take an IBC official under the current legal regime, that person is going to go scot-free. He is either going to the High Court and nullify those regulations, or even you have what we call a defective charge sheet, because there is no express offense provided for in the law and express penalty, which is a standard practice in criminal law. And that is what we are doing. In any event, and again, no prejudice is going to be occasioned by Raila Odinga if we pass that proposal. Okay,
Dr. Kama, I know you hadn't finished making your point. I am coming to you. I am coming to you.
Well, I think looking at it again, even to extend that conversation forward, I know part of what NASA has been demanding when they complain about IEBC is that question of who takes responsibility. Is it individual responsibility? I know they have cited specific individuals, or do you talk about now these specific provisions that seek to, prescribe specific fines for specific people within the system? But what I wanted to bring back is that issue of the bipartisan approach. Now, something positive, which I would consider positive, yesterday if you listen to Orengo after the bombers talks, if I can call them that, and I think also Norman Maga at some point, they seem to have softened the stand. When you talk of irreducible minimums, it means we can't go below that. But there's a sense in which they opened the possibility that talking would be useful. The only question is there are certain provisions or contexts that are provided for the law by the law in which to engage. And what I'm thinking at this point in time, because I know the question is coming up, whether shouldn't this be actually something that people can agree on, because we are all players in this particular game. But would they be willing then, in that case, saying that they are willing to, talk about these issues and maybe move away from some of the irreducible demands and move towards building consensus, even regarding this law, because both are likely to be affected by these specific laws. Does that mean, for example, is it coming back to Parliament, where, of course, initially they had said they were not willing to participate? Is it the Kamukunjis before these issues are actually discussed on the floor, so that they make sure the views that are being raised currently by the public, and if you have followed keenly, there are those people who are supporting the amendments, there are those who have also vehemently opposed, and I think these issues are being factored in by the committee. If then that could form the basis of certain discussions in the Kamukunji, where Parliament they normally do this, so that eventually they can agree, and like we said earlier, some of the provisions are good and they are meant to cure certain provisions that exist in law, and they can be useful. The others are contentious. Can we find a way then of moving forward and agreeing on some of these issues so that we make sure everybody feels confident going forward?
Yeah, I think there is one thing that we need to consider: the inevitability and indeed the necessity of this moment. Where we are right now is that these processes are already ongoing. The oath has already bolted. So the opportunity that we have right now as Kenyans from across every divide, politically, even from individuals and even institutions, is to enrich this process. And it is refreshing to see Kenyans really taking this public participation seriously and availing themselves to City Hall and giving their submissions. So what is pertinent, the only tragedy in this is the decision by one side, as I said earlier, not to participate. Thus the lack of the bipartisan approach to this amendment. But the game changer in these laws shall be in the flow of the House, when now members shall be taking votes on specific clauses, just trying to amend them finally before it is passed. So I hope, even though there's been a boycott of the committee hearings, at the level of the House, when the House now convenes to discuss this, and then prior to passing them, that both members from both sides of the political divide shall really take it upon themselves to come in and participate, because they say this thing is inevitable. Where we are right now, we are at that point where the process can really not be stopped. And there are some good values. There is value in these amendments. So if you ask ourselves the question, do we need to enhance our laws? The answer is yes. Are our laws perfect? No. So if you have amendments that speak to issues of enhancing the governance systems of our electoral management institution, amendments that will even introduce more fail-safe mechanisms into the process of doing the elections, and even amendments that will bring more clarity to the process of doing our elections, then why would you oppose that on the basis of an ongoing political, just an ongoing contest that is so contested? But yet, you know, these are laws that will serve Kenya, not just for this election. Of course, we are not discounting the fact that these elections, these amendments are really being rushed, because there is need to have the repeat poll in a manner that is better, that will reduce contestations. But there is a question of posterity. So the point that I really want to stress, and a plea to our political leaders across the divide, is that instead of boycotting, considering the inevitability and the necessity of the moment that we find ourselves as a country right now, take time to participate in it, not just criticize outside, and then when the opportunity to add value or even oppose it where it matters, you do not show up. I think as members of parliament, they should avail themselves, especially at the plenary, at the committee stages, even of the whole house, so that they are able to say, okay, we have a problem with this clause, this is what to suggest, we take a vote, and even if your provisions shall not sail through, you shall be heard. And Kenyans will say, even if you made bad laws, when you had the opportunity, you spoke, and Kenyans heard you.
Let me come to you all with a closing question. And earlier, I think the very first submission that we heard this morning before the Joint Committee, one of the officials was saying that, you know, in his submission, that the President and the presidency is a symbol of national unity as envisioned in the Constitution, and therefore it behoves the incumbent to ensure that going into this election, even if he was to win, not to win under the cloud of a process that would nip away at that high threshold of being a symbol of national unity, that he can't go in under circumstances that would appear controversial. In the context of these laws, is that what we are seeing, and what do you think the import of that particular submission this morning before the committee was? Let me start with you, Joseph, and run down.
Fair enough. First of all, just to say without any fear of contradiction, is that I know that NASA will never be party to those laws. So all these things about saying that hopefully they'll come at committee stage or at any other stage, I know that will not happen, because it will be like sanitizing, you know, what already it has pointed out that it's unacceptable. And of course that it's known that this is just a negotiating position, that, you know, Jubilee thinks that, you know, if they cannot listen, if they insist on the IEBC being reformed, then let's throw this at them, and then we can negotiate. But of course I know that I've heard it publicly said that NASA refuses to negotiate on that basis, because then it shows lack of good faith. And then the second thing is what is NASA's position on negotiations? Because I just had Matari here say that they were rigid, or they had a rigid position, but now they've softened. I think when you say in a process where you engage and you understand that you're the one who is asking for discussion and negotiation, you go in with your position. You cannot go into a negotiation and, of course, you go in pushing for your position, but you cannot go in and say that, and with the mind that this is what will be, come what may, come rain or shine. But you go in very strongly pushing for your position. Why am I emphasizing that? I emphasize that based on the knowledge that the team from NASA has all through been willing to negotiate. And even when you just observe what has happened around initially anniversary towers and then bombers, when the IBC invites, they very willingly and very quickly make themselves available, unlike the Jubilee candidate who has made himself completely unavailable for discussions and negotiation. So I'm saying that let's all read when it's demonstrated, let's read good faith. But when it's also demonstrated, let us see bad faith for what it is and name it for what it is. Finally, on what you say, I don't think for what he has shown, President Kenyatta right now is capable of regaining that image of a symbol of unity. And why do I say that? I must justify that because it's a serious allegation I'm making. Immediately after the pronunciation of the Supreme Court, the things the president had to say about not even NASA, just about the judiciary, the court, yes, they are not words that should come out of someone who is aware that he is a symbol of national unity. He would have been extremely measured, however disappointed and hurt, he would have been extremely measured. So that and the retinue of many other things, for me, have made me just give up and say that I do not think he's capable of, leaving that embodiment of symbol of national unity. All right,
Dr. Kamau, to the extent that Jubilee would want this to go their way and for the incumbent to remain as such, is this process, including the electoral laws, compromising that symbol of national unity?
And what I would say is, first, of course, you have to understand that President Uhuru Kenyatta is both the president, but also a candidate in this particular election. At times, it's hard to distinguish or separate the two always. But I think one thing that is important and has to be said is that we have always agreed and said that this country is divided. And it means then that process of bringing people together must involve all sides. It's not just the responsibility of one person. In other words, if as the president I am trying from my end, I can only unite people who want to be united. We know that it's a political competition, but they will never achieve 100% consensus and agreement. At the end of it all, there's somebody who will have lost, there's somebody who will have won, there's somebody who will feel aggrieved in a sense, but they need to feel that it was a fair process. Having said that, I remember back in 2007 and 2008 when they had disputed elections, when we saw finally President Mwai Kibaki and the former Prime Minister Raila Odinga shake hands, it sent a message to the nation. And I think what is important at this particular point in time, and that is why I said and I noticed yesterday, and it was repeated a couple of times, the way James Orengo spoke after the bombers talked, and later Norman in a certain forum, you could tell there is a softening of positions or opening the possibility, because we are confronted by the reality that we are going to have elections on 26, and people have to find, there has to be a meeting of minds, and you have to find a way of breaking the deadlocks. If these two positions, the irreducible minimums, and I have to say when you're approaching negotiations, yes, you have to have your demands, but then you have to be willing to soften so that we meet somewhere. If the two are meant to weigh against each other and say that we can actually achieve consensus because we have to as a country, then I think there is hope on my side that the fact that there is some kind of conversation taking place, and eventually there will be a meeting of minds and we can move together as a country.
Irungu, again, the presentation on the symbol of national unity in the context of passing electoral laws that may create a perception of controversy in the election of a person who's supposed to assume this symbol.
Well, these proposals are indeed geared towards cementing President Uhuru as a symbol of the national unity. Because if at all we have a situation where IBC officials will not be signing documents, they will not be appending stamps on certain forms, it will be President Uhuru who will be blamed by the country. If you have a situation where we have errant IBC official doing something wrong which cannot be punished, or we have a situation where, for instance, the chair of the IBC goes on leave and there is no one who can deputize him because the law is silent on that, it will be the President who will be accused of that. I think this idea of public perception tends to rhyme that public perception is only NASA perception. I think Jubilee as a party is the party that has best manifested itself as a national party. In terms of representation, we have members of parliament and senators from the entire former 8 provinces, unlike our competitors where you see their representation is in a certain area. And therefore, I think once they come into law, they represent the best symbol of national unity.
Okay, you just have under a minute. I beg your pardon, Charles.
Yeah, thank you. I think it's tragic that the confession that NASA shall not be part of this is a tragic confession because this is a national process. But the saving grace is that the goalposts of our politics are not permanent. We have seen them shift before, and I know they'll shift this time around. They said they shall not come to Bunge. They came. So I hope that something else will happen and substance will come, because these are laws that we give unto ourselves for the moment and unto posterity. And on the issue of the laws, there is need to deconstruct them as a one-party or a Jubilee party agenda and to make them a national process that we give unto ourselves to enhance our laws, because the laws belongs to we the people, not we the party of Jubilee.
All right, and that's our time. I thank all my guests throughout the 3 hours of Citizen Extra in English. I am Anki Guta. Have a wonderful day. Citizen Extra continues in Swahili. Stay with us.